Hello everyone, we are now onto the third segment of this introductory sort of lecture into wills and estates. What we're going to do in this third segment is have a look at estates. Um, by estates, we'll be looking at the process for winding up an estate. So I'm sort of going to give you a step-by-step sort of process. Um, if you and as executor have a will or are the executor of a particular will, and now you need to wind the estate up. So this will be the theoretical part to estates. Okay, so step one, when you're in charge of winding up an estate, is you will obviously need to go and report the estate to the master. Okay, the object of step one is you need to obtain a letter of executorship. This is a letter from the master that gives you authority to wind up the particular estate. Okay, so we need to know what documents or what things need to be submitted to the master in order to obtain this letter of executorship, which is referred to as reporting the estate. So first things first, there's a number, you would have to look at the scenario you're in, will obviously will determine what documents need to go, but there's a number of documents that should always be there. Number one, there's a document called the death notice. Now this is, if you want to sum it up, details or particulars of the deceased. There's another document referred to as an inventory. Now, an inventory is a list of all the assets in the estate, which is very important, but we'll come to now why that's so important. Another document is the acceptance of trust. Now, this would be details of the executor in that regard. So these are standard, standard documentation that needs to be accompanied when you're reporting the estate, being the death notice, acceptance of trust, and inventory. Okay, there's other things. There is a reporting declaration, a marriage declaration, which is obviously very, very important. I mean, your marital state is going to play a big part in claims in terms of the estate. If we think practically about it, what other things would we need in order to report an estate? We would need an original will. Okay, the will needs to be shown. There is a will. That is why the estate will evolve. Testate and not intestate. The next of kin affidavit is important. If the deceased is married, was married at the time of death, then we'll need to figure out what the marriage regime was. So if it's out of community of property, we'll need to give the antenuptial contract. I mean, if it was a marriage in community of property, the marriage certificate is obviously going to indicate that. If someone was divorced and they passed away, the divorce order is very important as well. We need to establish if there's children. That's part of that's going to form part of this estate. Get identity documents or birth certificates of children. In other words, we are reporting to the master that this person has passed away through the death notice. Obviously, guys, if there's a death notice, a death certificate is very important to prove this person has passed away. This person has passed away. He has documentation confirming details of this person and their estate. Then when it comes to who's going to inherit, I've indicated the marriage regime that the person was involved in through the ANC or the marriage certificate itself. I've shown the will if there is one. I've indicated birth certificates of children to show if they're going to inherit. So I'm giving the master an idea of this person's estate. That's the purpose thereof. I report the estate to the master and they give me what is referred to as a letter of executorship. That's step one. I may now proceed to wind up this estate. Okay, very, very important. I mentioned there, we spoke about the inventory document, which was the assets. And I said that's exceptionally important as well. And the reason is this inventory is sort of an estimation, a list of the value of the estate of the deceased person. Okay, why it's important is if the assets in the estate are valued at more than 250,000 rand, then we just proceed with the normal proceedings and we obtain a letter of executorship. However, if the assets in the estate are less than 215,000 rand, then the estate is referred to as a Section 18 subsection 3 estate. Right? You will not then receive a letter of executorship to proceed. You will receive a letter of authority. Okay, so please have a look at that in your guys' books as well. Okay. Anyways, let's say we have our letter of executorship. What's our next step? We need to open an estate bank account, right? This is very important because we need to create a system where all monies in the estate can be monitored and all monies need to be put in one single estate. So we're going to take all the cash in the estate, open a state bank account, and we're going to take all cash in the state and put it in that bank account and do transactions through that bank account. So we have transparency. We can show the master what we're doing, what has been done, and there's a clear chain to show what's happened to all the money, to make sure there's no fraud or theft or anything along those lines. Okay. So once we've opened the estate bank account, we can now proceed to do what is referred to as a notice to creditors. That's in terms of Section 29 of the Act. Now, a notice to creditors is an advertisement that we're going to place. This advertisement is going to be placed in the local newspaper, meaning the area in where the deceased resided prior to their death, as well as in the government gazette. Right? This advertisement is going to notify creditors of the deceased to say, listen, this person has now passed away. We are winding up the estate. You now need to institute a claim against the estate. Okay. You can do that advertisement. Practically speaking, if I know there's a bond over the property, I'm not going to just wait for the bank to see the advertisement. I'm going to notify the bank there's a deceased person that's got a bond with you, so you're going to have to institute a claim against the estate for the balance of the bond. You know, but requirements by law is you must do a notice to creditors by advertisement. Okay. Importantly, this notice gives them not less than 30 days and not more than 3 months to institute a claim against the estate. Guys, that is not 1 month to 3 months or 30 days to 90 days. That is not less than 30 days, not more than 3 months. Okay? That is how long they have to institute the claim. Okay? That was our step 3 after opening our bank account, was to do this Section 29 advertisements. Okay? Once we have obviously done the advertisement, then creditors will now be laying claim against the estate. Remember, we have our inventory that we did, so we know what the value of the estate is. Now we're getting asset-wise. Now we're getting a whole bunch of people or institutions laying claim, saying the state, this person owes them whatever money it may be. It might be a mortgage bond. It might be finance on a vehicle. It could be Johnny down the street who loaned you 20,000 rand. I'm not sure. Okay, but the crux being is once I know the value of the amount the estate owes to these creditors, I then can determine the solvency of the estate. Okay, so if the assets are more than the liabilities, great, we proceed. The issue comes in when the creditors exceed the asset value of the estate. You would agree that we now then have an insolvent estate. We now need to notify our creditors, especially our main creditors, and say, listen, the estate is insolvent, and they need to give direction. What should then follow? You know, sometimes they will say it's insolvent, fine, so we're not going to get the full amount. Proceed with the normal proceedings of winding up the estate. And other times they'll say, well, now we need to follow insolvency and follow the procedures set out there. Now, the reason why I've noticed sometimes a creditor would say, or the main creditors would say, let's not follow insolvency law, just follow the normal procedure and pay out what the estate can, is because that procedure costs less than the insolvency law, the procedure I've noted. And they figure out they will get a bigger amount of what's owing to them by just continuing simply with winding up the estate instead of starting insolvency law procedures. But that's a decision that will need to be made. Hopefully it's not an insolvent estate. All right. Great. Once we have our assets and we have our liabilities, we now get to the fun part, which is drafting the liquidation and distribution account. Guys, this is exceptionally important part of the work. I'm going to refer to it from now on as the L&D account. Okay, so the L&D account, we now as the executor proceed and draft this account. And it consists of various different sub-accounts. Just to mention them and to give you an understanding, because I think that's quite important. L&D account consists of the liquidation account. Now, the liquidation account is simply a list of your assets as well as a list of your liabilities. Okay? Assets minus liabilities will give you a balance that's left. Okay? That balance is what can be distributed in terms of your will or in terms of the law of intestate succession. Okay, so that is what we try and figure out in the liquidation account. Okay, with the liquidation account, we have another account that's referred to as a state duty account. Now, a state duty is also a liability in the liquidation account. That determines sort of your tax that you need to pay. So there's a way to calculate that. Okay, so assets minus your liabilities, which is your creditors, plus your estate duty, will give you a balance available for distribution. Okay, once we have that balance, we can now start looking at the will or the laws of intestate succession. Okay, so we move on to our third account, which is the distribution account. Now, the distribution account just indicates how your estate should be distributed. So if you have a will that says, let's say you're married in community of property, you would agree that your spouse is entitled to half your estate, right? So if you have a balance of 1 million rand from your liquidation account that's available for distribution and you're married in COP, then 500,000 rand you'll gift your spouse in your distribution account because of the marriage in community of property. And let's say you have a will that says everything must go to X. Then after you've given half of it away, you're next going to say the remaining half goes to X. So it's simply how the estate gets distributed in terms of the will or in terms of the law of intestate succession. Okay, so you can see how these accounts are reliant on each other. Liquidation account is sort of your main one, but it's reliant on the estate duty account because that figure needs to be calculated and added to the liquidation account. And the balance that's remaining gets passed over to our distribution account, and it gets distributed in terms of the will or in terms of the law of the intestate succession. Okay. There's a fourth account that I link very closely to these three, which is referred to as the recapitulation account. Okay. Now, what this account simply is to determine what the cash value of the estate is. Now, this is very important. Let's think practically about this. We might, in our liquidation account, have an asset value of 3 million, for example. But that may consist of immovable property, cars, furniture, etc., fixed assets. And we have liabilities of, let's say, 500,000 rand, creditors that we need to pay, and estate duty we need to pay. I can't go and pay these creditors with a couch. Right? I need to make sure there's enough cash in the estate to pay all of my liabilities. So simply what the recapitulation account is about is determining what is the cash value of your estate. And then you think, then once you've determined the cash value, you then go further to mention what are all the things that need to be paid in cash. Okay, you subtract the figure from one another, and then you're going to see whether you have enough cash in your estate. So you're either going to have a cash surplus or a cash deficit. Now, if you have a cash surplus, awesome, we can proceed. If you have a cash deficit, you know now there's a shortfall of cash in the estate. Meaning what? How practically we're going to sort this out? The only way to achieve this would be to sell some assets in the estate for cash, so that we have more of a cash flow to pay all of our liabilities. So you see how important that account is to the rest of the accounts as well. Okay, those four work hand in hand for me. There's two other accounts, so there's sort of 6 sub-accounts within an L&D account. Okay, the other one is referred to as a fiduciary account. Now this is in case there is a fideicommissum. You recall from our testate law recording that we spoke of fideicommissum, where you can pass an asset on to one person. When they pass away, it needs to go to the second person. That person becomes the owner. If I'm the first person who receives the asset, I'm the fiduciary, right? But you agree that asset is not mine. I'm just using it, and I need to look after it because when I pass away, it's going to, for example, my children. I think that was the example we used there. My child, So I then create a fiduciary asset account that says, this is the property that I've been staying in, but I couldn't mention it as an asset in my liquidation account because it's not my asset. It's now going to the next person. Okay, so that would be the point of the fiduciary account. Then the other account, referred to as the income and expenditure account. Now, the reason why I've left this for last is, practically speaking, this is the own account that is sort of independent from the other accounts in the L&D account. So the whole purpose of the L&D account is your value at date of death, right? But there may be scenarios where your estate is making money or losing money after date of death. Okay. Practical example, I have properties that I lease out. I pass away now in June. July, there's still going to be rental income coming into my estate from the properties that I owned. Now, you agree that is rental income coming in after date of death. Okay, so that money is not reflected anywhere in my liquidation and distribution account because the L&D account is simply at date of death. So I create another account referred to as income and expenditure account, where I record all income after date of death and all expenditure after death over there. Okay, that is sort of the purpose of that account. So those are like the 6 sub-accounts that falls within the L&D account, and that is what you will be required to draft. Okay, if I remember, there was step 1, 2, 3, 4. This is about step 5. Okay. Once I've drafted my L&D account, I can then move to step 6. Okay, which is another advertisement. It's referred to a Section 35 advertisement, sort of another notice to everyone. What this notice is once again also published in the Gazette and published in the local newspaper. But this is a notice that goes out informing all interested parties in this estate. The interested party is anyone benefiting or any creditor of the estate, etc., etc., that the L&D has been drafted and it is now going to lie open for inspection for 21 days. Okay. What that means is you're telling everyone, you can go and have a look at this liquidation distribution account from this period to that period at this place, and you can have a look what you are receiving in terms of the account. Okay. Now the purpose or the point thereof is a creditor or someone who's supposed to inherit something can go and have a look what they're receiving from the estate, and they might have an issue. They might say, you've done this wrong. I'm not supposed to get that. I'm supposed to get this amount. And they can lodge an objection with the master and say, I'm not happy with the L&D account. It's wrong. Whoever has an issue with it can lodge an objection. Even the master, him or herself, can lodge an objection and say this L&D account is not accurate. Okay. The bad or the consequence, reality thereof, is that it's not accurate. You're going to have to redo it. And if you redo it, then you're going to have to re-advertise in terms of Section 35. It's costing money and it's costing time. So we obviously try and get this thing drafted as best as possible. Let's say you've done your advertisement, it's lied open for inspection for 21 days, and there was no objections. Or there was an objection, but you fixed it, you sorted it, you explained the scenario, and everyone's happy. Okay. That step is then complete. You can then move now on to distributing the estate. Okay. In terms of the L&D account. Once you've distributed the whole estate, you will then come to your last step. You'll show the master everything you've done, and you will then receive a filing slip, which sort of is basically indicating that your job is done at the end of the day. The estate has been successfully devolved or distributed upon everyone. Okay, so that is pretty much the process for winding up an estate. As you can see, the steps are quite easy. Not a lot of steps, quite easy to remember everything you must do. But the practicality thereof can sometimes become difficult. And the challenges lie sometimes with the L&D account itself. Because there is alternative things you can do that you need to have a look at. For example, you can do a redistribution agreement. For example, if X is supposed to receive this and Y is supposed to receive that, you can redistribute it. X can take Y's thing, Y can take X's inheritance, but all that stuff will then need to be recorded. And another important aspect that I think you need to be quite well aware of is the Section 38 takeover. What that implies is sometimes, when we do a will, we are ill-advised or we are not advised, and our estate planning is not up to scratch. Let's give a practical example. I have a wife and 2 kids, and I don't really have cash flow, but I have a immovable property. And my will simply says, if I pass away, my estate needs to be divided amongst the spouse and children. Now I pass away and my children are still in primary school, and there's just a house. Now that house must go divided between the 3 of them, but there's no cash flow. How does that spouse continue and look after the children, etc. You're going to have to lose your marital home, which can be impractical. So a surviving spouse can apply for a Section 38 takeover, and the result is they can apply that the family home gets kept and no one can take the family home. And that purpose would obviously be so there's a roof over the head of him or herself and the children. There is a condition, and the condition is that as long as when you're doing the takeover, it is not prejudicing anyone at the end of the day. So those are things that need to be considered, but you can have a look at that in the notes as well. But yeah, guys, that is the theoretical part of estates and winding up an estate. There's the steps there too. That should sort of help you guys in terms of understanding what we are doing over there. We'll have one more segment where we'll look at the L&D account. It's a bit difficult in this type of video recording to explain that to you, but I'll try and give you guys an understanding of what we are doing there so that we have a bit of knowledge when we do reach our contact connections. All right, thank you.